Good afternoon. My name is James Trujari, and I'm the Executive Director at Legal Assistance for Seniors. It is my honor to welcome you to today's program, The Role of the Guardian at Litem, A View from the Bench and Best Practices, presented by Christina Nalchajian and Commissioner Ruben Sundeen. This is the third in our series of 4 webinars addressing various topics on elder abuse. As you all probably know, when we hold the conference in person, it takes many dedicated people and agencies coming together to produce such a large function. And this webinar series is no different. First, I would like to thank all of our sponsors who continue to support the conference in the webinar format. Their continued dedication and excitement for the work we do is critical to the success of the conference, and we offer our deepest gratitude. In particular, I'd like to thank our top 4 sponsors: Michael Stevens, Probate and Trust Realtor, our Diamond sponsor; Campbell Green, our Platinum sponsor; and our 2 Gold sponsors, the Tile Shop and Acuna Regli. Michael Stevens has been an incredible support to LAS and is always there to help with a great enthusiasm. If it involves supporting older adults, Michael is always there with a big yes, and how can I help? In addition to a high level of professionalism, Michael and his team at Highland Partners Real Estate bring much empathy and compassion to the many probate and trust sales they handle. Michael approaches each transaction, whether for his customers or working with conservators, attorneys, or other fiduciaries, with real understanding. Thanks to Highland Partners and Michael for your steadfast support of LAS over the years. Philip Campbell has been with LAS long before I came on board. For anything big or small, Phil is always helping LAS. From Campbell Green themed M&Ms to guiding the agency by volunteering to be the board president, Phil believes in older adults in LAS. Campbell Green is another of our longtime benefactors. Many of you know their legal practice in estate planning, probate and trust administration, and conservatorship and elder protection. But we here at LAS know Phil and his team as great friends and champions of the rights of older adults. Thank you, Phil and Campbell Green, for always being there. The Tile Shop, with their showroom in neighboring Berkeley, and Acuna Regli with business in estate planning, probate and trust administration, and conservatorship and special need trusts, are our 2 Gold sponsors and have been supporting LAS's work around preventing elder abuse for many years. They are always there to support this work, and we really do appreciate that they continue to believe in the work we do. Thank you again to Tile Shop and Acuna Regli. We have a whole host of sponsors at the silver and bronze levels that we are also incredibly grateful for. Many of these sponsors, like our Diamond, Platinum, and Gold sponsors, have been supporting this work for many years. They are our collaborators and partners and keep us excited to continue to do this work. At the silver level, we have Anderson, Yadzi, Wang, Minton, and Horn, Fiduciary Accounting Services, Holland and Knight, and the Professional Fiduciary Association of California, or PFAC. At the bronze level, we have 21st Century Care Solutions, ARM Homes, Evans Law Firm, Golden Gate Fiduciary Services, IMT Associates, the Law Offices of Sonoy Rousseau, and the law offices of Phillips & Phillips and Lifelong Medical. We really appreciate all of our sponsors at the silver and bronze levels. And a special thanks go out to Office Information Systems and Supervisor Wilma Chan for their support of the conference. In addition, Golden Gate University has continued to support LAS in this webinar series with technical support and serving as an honorary event host. The Institute on Aging and their amazing staff continue to be wonderful partners in providing continuing education units for a wide variety of professionals. Last but not least is the team that has contributed their time and hard work over the past several months to transition this in-person conference to an online experience. Greg Bedard, Jenny Pardini, and the entire LAS staff. We truly appreciate all the work they have done. For those of you who have been coming to the conference regularly over the years, you might notice that there is a familiar name missing from that thank you list. LAS lost our colleague and dear friend, Katie Brady, earlier this year. Her bright smile and positive energy will be sorely missed at the conference and throughout the year at the many events that she would attend. Katie was a champion for older adults, a thoughtful and caring coworker, and an avid softball player. Katie brightened any room she walked into. And as Katie used to say, go team, go. Now, for some housekeeping, before we get started with today's program, we have a wonderful educational presentation followed by a live Q&A. If you have a question, please submit it through the Q&A icon at the bottom of your screen. Staff will be monitoring these questions for the moderator. We will try to get to all of your questions, but if we're unable to answer everything during the session, we will do our best to follow up with you after the presentation. For those of you who need continuing education units, you will receive a post-event email within a day or two of this session with steps on redeeming your credit. Lastly, we welcome your feedback to help us improve your experience and continue to offer high-quality education through a post-event survey. As I'm sure you're aware, today's presentation is part of a series of 4 webinars LAS is producing in the coming weeks. They are all free of charge and open to the public, though a donation of $25 per webinar will be gratefully appreciated and accepted in order to support our ongoing work. We hope you find these presentations informative and useful. You can register for these webinars by visiting our website at lashighcap.org. That's LASHICAP.org. and going to the events page. Thank you again for joining us, and I hope you enjoy the program.
Good afternoon. My name is Jenny Pardini, and I'm the Community Education Coordinator with Legal Assistance for Seniors. I'm delighted to be your moderator for this webinar. Today, you will hear a 1-hour educational presentation from our guest speakers, followed by a Q&A that I will be moderating. If you have any questions for our speakers, please submit them at any point during the program by clicking on the Q&A icon at the bottom of the meeting screen. If you have any technical issues, you can ask us in the chat, and our technical team will do their best to assist you. If you would like to use the closed caption feature, click on live transcript at the bottom of the meeting screen and choose show subtitle. It is my pleasure to introduce you to today's speakers, Christina Nalchajian and Ruben Sundeen. Christina Nalchajian is currently the owner of Nalchajian Whitley Law based in Oakland, California, where she specializes in probate and trust administration, estate planning, conservatorship, and elder law. Previous experience includes practice of the law as a solo practitioner with the civil and criminal practice focused on family law, in addition to her background as a deputy district attorney in Fresno, California. Ms. Nalchajian obtained her Master of Law degree in estate planning and probate law from Golden Gate School of Law. Prior to this, she obtained her Juris Doctor degree from the University of San Francisco School of Law, during which time she served as a research assistant for the United States District Court. Since 2019, the Honorable Ruben Sundeen has served as Commissioner of the Superior Court of California in Alameda County, assigned to the Probate Department 201, conducting procedural and evidentiary hearings and trials of all matters falling under the California Probate Code, including probate, trust, guardianship, and conservatorship matters. Prior to this engagement, Commissioner Sundeen was a partner at Sundeen, Salinas, and Pyle, based in Oakland, California, for 20 years. Mr. Sundeen served as principal and managing attorney with general civil practice, emphasizing trust and estate litigation, as well as real estate and commercial transactions and litigation. Commissioner Sundeen is a graduate of UC Berkeley School of Law, during which time he was both a member of the California Law Review and president of the Bolt Hall Students Association. Christina and Ruben, welcome to the program.
Thank you.
I think I'll start things off initially with another housekeeping item. You should all have access to the PowerPoint that we will soon be sharing on screen. There are essentially 22 substantive slides, and we have no intention of sticking strictly to the PowerPoint script, but hope to use it as a launching pad for discussion. First wanted to say, I think there'll be an uptick in the use of court-appointed guardians ad litem as the baby boom generation continues to age. As logic would have it, where there is a rapidly increasing large aging population, there's a logical increase in the need for protective proceedings. And I think we're all seeing more trust litigation where allegations of lack of capacity are often made. And this is happening increasingly while the trust settlor is alive. Some local courts and judicial officers, bench officers are more in tune and adept at appointing and utilizing a guardian ad litem. My personal suspicion is that the role of the guardian ad litem will receive increased attention as we have this aging population to deal with, and that we'll also see a fine tuning of the California rules of court and local rules regarding the process for appointment and use of guardians ad litem. So with that little intro, Commissioner Sundeen, I will kick it off to you, and I'll also start our screen share.
Right. Thank you, Christina. So why don't you go to the first page, or I guess page 2 of our little PD or PPF, what is it, PowerPoint, whatever. So I'll piggyback on what Christina said insofar as you all can read. So we have these slides, you'll get a copy of it. We're not going to read the slides to you, rather we're going to use this as a launching point for further discussion. What is a guardian ad litem? First question. It's basically someone to stand in the shoes in a legal proceeding for someone who's incompetent. My favorite example is, what if I have a 2-year-old who's got some legal claims? They can't pursue it on their own behalf. We need a competent adult to manage it. But doesn't mean that the court gives up their supervisory function. And that's what, for example, the second bullet point is all about, is Barry v. Chaplin, in which it says really the court's the guardian of the person, and they're appointing this individual to do their work for them to help protect the interest of an incompetent person. Now, I did a little follow-up on the Barry v. Chaplin case. Chaplin's full name was Charles Spencer Chaplin, i.e. Sir Charlie Chaplin of silent movie fame. And it's an actually interesting case insofar as when he was 52, he started having an affair, if you will, a relationship with a 22-year-old young actress, Barry, and she got pregnant. And there was Barry's mom became guardian ad litem for the child and sought a paternity action and support action. And the mom entered into an agreement for resolution of the dispute, whereby if there's some blood tests by 3 different doctors and they show that he's not the father, then they dismiss the support claim. But if he's found to be the father, then he pays support. And there were 3 different blood tests, all unanimously confirming that Charlie Chaplin was not the father. The court even approved of this stipulated procedure. And then the mom backed out, grandma backed out, and then a new guardian ad litem came in with new lawyers. And they said, no, we're not dismissing this claim. And Charlie Chaplin's lawyers sought judgment on the pleadings, a demur, based on the stipulation, and the court refused to enforce it. That was Stanley Mosk, who became a California Supreme Court justice. And they tried multiple times and the court kept rejecting it. They finally went to a jury trial, because you could jury trial back in the day. And the jury found that Charlie was the father of the minor child. Part of it was because the blood tests were inadmissible. And so the question is, well, what happened? There was an agreement, a resolution, even court approval. And this is what I take from the process, is that if you're going to settle, you of course need court approval, but you've got to horse trade something. You got to get something back. And what this guardian ad litem did was basically agree to some alternative process, which frankly did not require verified medical reports / blood tests. And the court thought that they couldn't agree to some other process for resolution, i.e. win-lose. That's not a settlement. That's agreeing to some alternative procedure, and that's abrogating the right to the court to oversee the affairs of an incompetent person. And so that helps kind of understand what your role, what a guardian ad litem can do, is they can pursue things, they can settle claims with court approval, but they can't agree to some other process that takes away the court's role to oversee these affairs. In doing further research, apparently in a subsequent divorce, Charlie's future ex-wife reported that he paid off people to get those blood test results. Whether that's true or not, who knows? But after the Charlie Chaplin case, actually, there was a California law that made blood tests conclusive for establishing paternity. But I thought it was interesting. And then the next case about the quasi-judicial immunity, and I'll go quickly, is McClintock versus West. McClintock was a lawyer in a divorce proceeding, and he didn't show up for trial. And his lawyer said, oh, he's in the hospital, he's having a mental breakdown. And the court didn't believe him. Then they got proof he's in the hospital. So then the court appointed the guardian ad litem. And after 2 years, the guardian ad litem settled different claims, offered exchange information, and McClintock lost custody of his kids, and then tried to sue the guardian ad litem for breach of fiduciary duty, malfeasance, blah, blah, blah. One, the court basically thought McClintock was a liar. They didn't say it, but they thought he was a liar. But they pointed out that a guardian ad litem isn't a lawyer representing someone, isn't even really a party. And that's what we'll talk about. They're like quasi parties, they're quasi not parties. They're kind of like have a role of an advocate, but they're not an advocate. So anyway, there's absolute quasi judicial immunity. They also relied upon the litigation privilege at Code of Civil Procedure 47, which basically says in a legal proceeding, I can say anything. I can say that I believe Christina, believes in ghosts, whether that's true or not. And the purpose is, and I could have been more crazy when my example, Christina, but the point is to facilitate the free exchange of information. And but let me keep going. So I'm rambling. The origin of this is the Wedland case. Everyone knows that case. That's where the conservatee spouse wanted to remove her disabled spouse from nutrition and hydration. And there was a pretty good body of evidence that that's what he wanted, but mother and sister didn't want that and wanted him kept on nutrition and hydration. And the court found that you need clear and convincing evidence that this is the person's wishes. But they pointed out that under a DNR, that's protecting someone's privacy right to bodily integrity. Whereas with a GAL, that's the parens patrae, or I don't know even how you pronounce Latin, but that's basically the government is the parent of incompetent people. And under that, the authority that the court has is much more limited. And so anyway, so that doesn't make that much of a difference, other than I think being circumspect in pursuing those claims and rights that one sees as a guardian ad litem. And we can talk about that further. And there's 2 sections for guardian ad litem. It's statutory, but there's also a body of common law for support of guardian ad litems. The main one is CCP 372. That's all the cases on guardian ad litems are under 372. But probate code section has their own special guardian ad litem statute. And the beauty of this one is that the court can order fees from any party in a proceeding to pay the guardian ad litem fees. And so if one has a guardian ad litem, or if one is a guardian ad litem, you can use that as a leverage tool. That, hey, I'm going to ask the court to have my fees paid from your half because you're not cooperating. And it's happened rarely, but I know it's happened for me once when I was a guardian ad litem. So just be aware that you've got that unique tool that's not available under the CCP guardian ad litem statute. And then 1003 basically says all the incompetent people, some are perfunctory, like an unborn person, they need someone. But a lot of what we'll talk about is discretionary appointments and what you do in discretionary appointments. Thank you, Christina, you're way ahead of me. Next, I think you're next.
I think so. So guardian ad litem fees, and Commissioner Sundeen briefly touched on this just a second ago, part of what I'll discuss. But I essentially think of the court is hiring the guardian ad litem, and the court supervises and sets and awards fees. I will say I have seen a little wiggle room with how fees are reviewed. in certain trust matters on the order for appointment of guardian ad litem, I have seen language in an attachment saying something such as the court authorizes the trustee to pay guardian ad litem fees without further order of the court. And there was no objection to that or opposition. So I think there is a little wiggle room, generally not the case. It may be possible. Something Commissioner Sundeen just touched on.
Well, can I follow up on that one thing, Christina? Because I've done that a couple times from the bench, and it's whereby it saves the filing fee and saves time for filing the petition, and if everyone's on board. But that doesn't mean that if there's a dispute, you can't come to court. And finally, as far as fees, let me tell you my perspective is that usually people are not consenting or hiring you as a lawyer if the guardian ad litem is a lawyer. And so I think it's really important to be very circumspect and very efficient in your services, because this isn't by choice. This is by fiat, by imposition. And granted, it's a critical role that we'll talk about later, but just be very sensitive about that. I'll just leave it at that. That was my 2 cents.
Absolutely. I mean, I'm in complete agreement, and I'm often even trying to, as far as if there is a settlement or if there is something in the works, I'll say, well, so I don't have to bill, why don't you draft it up and then I'll have a go at it. You know, because it just, I'm always conscious of costs and efficiency. Some cases, you know, money is not as much of an issue, but I sort of always approach it that way. Also wanted to mention, possible, doesn't happen often, but it's possible to not get paid, even when your fees are approved and you receive a court order. I always say a good indicator is if the party who is supposed to pay your fees strongly objected to your appointment in the first place. Of course, the court, the bench officer has wiggle room as to who they can order to pay fees, a particular party, the estate, etc. But there could be a possibility or rarely, I mean, it hasn't happened to me yet, but that you never know, where you'll be attempting to collect on a judgment or enforce an order on your own. I don't think the court would routinely use a contempt power in order to get a guardian get money in my pocket as a guardian ad litem. Now, next, do you have anything to add to that, Commissioner Sundeen?
No, other than courts are very hesitant to use contempt power. In fact, as a commissioner, I don't have contempt power except for what they call direct contempts, i.e. contempts in front of me, because there's indirect, there's hybrid, and there's direct contempt. I only have authority over direct contempt. So just it's kind of discouraged because the court's acting as a judge, jury, and executioner, and that's not our preferred role. There's my 2 cents.
All right. The authority of the guardian ad litem can waive procedural things such as waiving notice, no authority to settle or compromise a substantive right. One thing I wanted to touch on here is how does a guardian ad litem participate in a mediation and what are the best practices in doing so? I recommend if and when a guardian ad litem is participating in a mediation to maintain some independence during the mediation. You don't necessarily want to be in the same room as the other parties. You want to maintain your position of neutrality. And I think there's some confusion about that. A guardian ad litem can certainly participate in a mediation, review, engage in discussions, and can sign an approval as to form on a settlement agreement if a settlement is reached in a mediation, with full knowledge that there's going to be, court review of the settlement and approval by the court. Or, for instance, if one is a guardian ad litem is not okay with the settlement that's reached, that's something that a guardian ad litem can communicate to the parties as well. And let them know that, in the next report or, as that settlement is submitted for approval, that there will be an objection to the settlement in its current form from the guardian ad litem. Anything to add there, Commissioner Sundeen?
Yeah, one thing, everyone's talking about the Breslin case where the court can order people to go to mediation in a trust proceeding. And the offshoot of that is that if they settle and you didn't participate and your client's X'd out, tough luck. That doesn't apply with the guardian ad litem because the court's always going to look at what's going on. So you probably want the guardian ad litem there just to make sure you're not going too far off the rails when you enter the agreement, because you don't want to go to court approval of the settlement and then have the court say, no, that's not a good idea. And part of what I talked about the Barry v. Chaplin case is that distinction between substantive and procedural rights can get a little fuzzy. And that's what the Chaplin or Barry v. Chaplin case is all about, is that the procedural compromise or agreement was so significant that it ended up becoming a substantive right. And so just be careful on that. It's like the catch in football. Yeah, sometimes it's an obvious catch, sometimes it's an obvious drop, but when it gets fuzzy, you need to be careful.
I was hoping we could do this without a sports analogy, but you just had to go there.
That's how I understand the world, Christina. Sorry.
All right. This is sort of a what a GAL is not slide, because often when you're reading cases, how attorneys, legislators, how everyone has parsed out what a GAL is by describing what a GAL isn't. And there's been a lot of effort recently, legislative effort, to clean up the role of a court-appointed attorney and to emphasize that a court-appointed attorney should zealously represent their client. And then they contrast this to the role of the guardian ad litem. So a GAL has no client, generally no duty of confidentiality, and no attorney-client privilege. In fact, even though a GAL may be an attorney, we are not, as guardians ad litem, working as attorneys. We're as sort of an arm of the court, and one doesn't have to be an attorney to be a GAL. That's something we'll touch on in just a bit. So I think there's a lot of confusion about what a GAL does and the fact that a guardian or guardians ad litem don't have any clients. I feel that a best practice is to, when I am appointed a guardian ad litem in a matter, to let the parties and counsel know where I think I stand, so that there isn't confusion or request that I not disclose something to the court. I'm appointed generally to investigate and report to the court. I'm an arm of the court in this role. So I like to say, once I'm on board, say, hey, just want to let you know, as far as I'm concerned, I have no privilege, no confidentiality, no duty of loyalty. My goal is to figure out, in my opinion, what the best interest of this ward is, and then report that to the court. Anything to add there, Commissioner Sundeen?
Yeah, for context, one is, in many ways, a guardian ad litem is the eyes and ears of the court. And let me explain what I mean. We have court investigators, and I saw some on our attendance list today, but we only got like 6 or 7, and we've got thousands of guardianships and conservatorships. They cannot get deep into the woods on many of them. And so where things are a little crazy, and also, for better or worse, the reality is where there's resources to pay for a guardian ad litem, the court may appoint a guardian ad litem to dig deeper into something, to try to find a neutral fact finder to figure out what's really in this person's best interest. And I always took the position that my job when I was a guardian ad litem wasn't to judge people's life choices and values. Is if they want to run around naked in their backyard, I don't care. If they want to, lie in a pool of Jell-O, I don't care, whatever. But it came to health and safety, and where things, again, where the boundary is, what if they want to eat cake all day? Well, they can eat cake all day, but that may not be the healthiest. So there's certain boundaries you have to have. But other than that, I wanted to respect the life choices and values of my ward and just make sure that their interests are being protected. When it's financial, it's a lot easier in black and white, where it's conservatorship of the estate, for example, and they're hanging out with people who maybe aren't the best characters in the world. That's where it can get a little dicey, but that's where your services are needed the most.
Next slide is GAL and discovery. I always like to say this is where things get a bit strange, in that you'll see language and in the cases saying, you know, GAL is more than an attorney, but less than a party, you know, the role of the GAL. Generally, however, a GAL is a party as far as discovery is concerned. A GAL can be deposed, a GAL can be called as a witness. A GAL could conceivably issue formal discovery. I don't think this is common. I think it can happen. I think it's rare, but it is an option. You know, guardians ad litem can respond to interrogatories, etc. And remember, you're not an attorney, you have no client, so there's no privilege. There are a lot of the things you would normally assert in your attorney role representing your client would not be available here. And you just want, I think the goal is a neutral position and disclosure to the court and to the parties as well, regarding what you're doing and how you're doing it.
Yeah, I'll follow up. I think you mentioned this before, Christina. It's just being upfront that anything said to the guardian ad litem is going to be, it could be disclosed to the other side. You don't have to necessarily volunteer it, but if they ask for it, you've got to give it up. And yeah, when I was guardian ad litem, there were a couple instances where people served discovery upon me, and I don't think I ever served discovery. Even when I wanted to talk to someone, I just said, I just want to talk. I just want to find out what's going on. It doesn't even need to be in a penalty of perjury, you know. And I always thought people should want to talk to the guardian ad litem to get them on their side, you know, and then you can hear all the stories and make up your own mind as far as what's really going on. But I think just good communication with everybody up front, establishing a rapport, you know, that you're not here to judge anyone, just here to neutral to help get information to the court, hopefully can avoid the need for formal discovery, because no one likes that.
And it certainly, as we all know, runs up costs. Like, the next slide discusses, and we've touched on this already, who can be a guardian ad litem. Doesn't have to be an attorney. This is a role where a private professional fiduciary could certainly develop a role, you know, a reputation serving in this capacity in a court system. Parents are often serving as guardians ad litem. In fact, a lot of the case law for minors, personal injury cases, etc., involves the role of a parent serving as a guardian ad litem. Appointments left to the bench officer's discretion. So there can't really be a cat fight about that. And courts do it different ways. I think I'll touch on that in a different slide. And we can probably move on to the next one. So slide number 9, I think that's for you, Commissioner Sundeen.
All right. We have statutes for appointment of a guardian ad litem, but they date way back to pre-statute common law. And so the court, frankly, has inherent authority under the patrons, patriae, however you pronounce it, concept, theory, whatever you want to call it, to appoint a guardian ad litem to represent an incompetent or incapacitated person. And that's at any time. And so it really depends upon, I can't draw any conclusions, frankly, in my experience, both on one side of the bench or the other, as far as when's a good time, when's the proper time. Other than I would just say that I'm conscious of cost and I don't want to bring one in unless I think it's worth the money. Let's see. Yeah, so thank you. You moved a little faster than me, but that's all right, Christina. I was just going to ramble.
I can go back.
No, I was just going to ramble, which is my standard MO. So that's what I mentioned, the snowball case, that's really what it's all about, is when there's conflicting positions. 90% of the time you're going to get appointed when there's conflicting positions, or, and there are rare cases where there's been like some pretty overt conversion of funds and we just need someone to recover and figure out what that line is for recovery. The snowball case actually involved a a guardian ad litem who sought support from a trustee, and the trustee didn't want to give up that much support. And so it was two conflicting ideas of what's the proper level of support for some minor beneficiaries. And that's a classic case, is the mother guardian ad litem wants a lot of money. The trustee who was holding the money wanted to save the money for the kids, and the court wanted to find some middle ground, and so appointed a guardian ad litem. And I mentioned this before, all your authority is going to be in the general CCP with regard to minor children, because that's usually what the ones where people are going to appeal. Like anything in life, you've got to analogize and find your authority where it is. And that's where you're going to find it.
I'm going to jump in here and say, I do think that we're going to start seeing more case law and legislation, coming out of probate involving Probate Code 103, and as things proceed in the next decade or so. I wouldn't be surprised.
So I know there's somewhat of a dispute, is can a court appoint the guardian ad litem for someone who has yet to be conserved or is subject to a general/probate conservatorship? In re Sarah D, that was actually, it's in the dependency context under Welfare and Execution Codes 300. Mom was bipolar. The court thought that she was unable to protect her own interest in as to custody of her children, and so appointed a guardian ad litem, and she didn't like it because the guardian ad litem disagreed with her. And I'll just say is that in that case, the question was the process by which there's appointment of a guardian ad litem where the principal or the ward disagrees, and the court required at least some informal opportunity to hear about the ward or principal before the appointment. It doesn't have to be a notice motion, doesn't have to be a formal hearing, but just give them a voice before you actually pull the trigger on that. And the court didn't necessarily disagree with the outcome of appointment, but the court thought that due process required an opportunity to hear from the preferences of this person. What's interesting is they didn't talk about whether it was from the court-appointed lawyer for the mom or the mother herself. I don't think they addressed that. But the principal situations are, I will say, a prima facie showing of undue influence, i.e. what I'm hearing from our ward or proposed conservatee or temporary conservatee doesn't make sense, i.e. there's some prima facie showing of undue influence, or like with the Snowball case, there's just different versions of reality, and we're trying to figure out what's the best version or where do things fall, because it's probably in between those different versions of reality. I mentioned before, like the fiduciary malfeasance, one thing is that even if you're going to recover converted assets, that's one thing, but also assessing the relationship. And is this a relationship we need to maintain, or can we just go after everything full bore and not worry about maintaining this relationship? And only a guardian ad litem, I think, can make that assessment. And so allegations of fiduciary malfeasance, if it's obviously it's a neutral trustee who converted assets, you go after them. If it's dad trustee or mom trustee who converted assets, well, then we're juggling other considerations, and that's what a guardian ad litem is for. And again, I think the last bullet point is the same. It's just trying to figure out what's best. 3100.
I'll jump in here and say I've been reading. I think there are a number of authors that are attempting to begin to tackle that concern, whether a guardian ad litem should be appointed prior to the establishment of a conservatorship. Commissioner Sundeen, you've already touched on this. Common practice and common law. Current pattern of practice is that judicial officers do routine and can appoint a guardian ad litem where there's a pending conservatorship petition. There's some debate as to whether ultimately that's the appropriate thing to do or not, since you have a presumption of capacity until you are found, to lack capacity. And I think we're going to see some litigation or legislation regarding this issue in the future. it's certainly an area that provokes strong opinions for some parties and some attorneys. We'll say that.
Yeah, my take. A guardian ad litem is just another voice in the room. And so it doesn't mean that I go with what the guardian ad litem says. It's just, I'm just looking for hopefully a neutral voice. So I think that the court's going to allow for guardian ad litems in the discretion and inherent authority of the court, but we'll see. I know people don't like it because there is some conceptual disconnect in appointing a guardian ad litem for a quote competent person.
Right. This is slide 13 is more sort of how to fill out the boxes. Generally, the petition for appointment of a guardian ad litem, DE 350 or the DE 351 order for appointment of guardian ad litem is used. Sometimes this is done sua sponte, informally, just you're nominated a guardian ad litem in court minutes. It's always, in my opinion, preferable to have a formal order. And sometimes the order is as broad as investigate and report, which tells me that my role is indeed that broad. And personally, I always think of my role broadly anyway. If there's an item of concern, I'm going to report it to the court, even if my specified duty on my order for appointment is to review bank statements for a specific bank. If I end up visiting somebody and who's alleged to lack capacity and their living situation is deplorable, the court's going to hear about it. Anything there, Commissioner Sundeen?
No, I'm fine with minute orders for appointment. I know that arguably a best practice is to use the form, but if I appoint someone, I appoint someone. But as far as like what the charge and role is bring all your tools to the table. We've got an incompetent person who maybe they're focused on this part of their legal affairs, but there may be some other tangential or ancillary issues and claims out there. And so I'm more than welcome individuals who can think big picture, think outside of the box, tell me what other claims this person may have. That's helpful, because these are all leverage points to figure out the right answer, to get people to do the right thing. You know, our laws are structured so that way, if properly followed, everyone's living a good life, and that's what we're trying to accomplish. So even if your charge is circumscribed and limited, you know, don't be afraid to comment on other things you may see, and then let the court say, hey, that is interesting, why don't you explore it more? But yeah, just bring all your tools. That's all I'd say.
I will also add that how one is appointed as a guardian ad litem is up for grabs depending on the courtroom and the county. It's sometimes a mystery to me. Some bench officers like to maintain a list and go one after the other on the list, no matter the case, just in order to maintain an air of neutrality. Other bench officers prefer to cherry pick a guardian ad litem for a specific case based on their knowledge of that person's abilities and interests, and their experience on the bench. And it just, in other counties, a party can even nominate a guardian ad litem, and unless there's any opposition to the proposed nomination, that guardian ad litem will likely get appointed. In other counties, that's not considered appropriate, because then that guardian ad litem does not have as much of an air of neutrality. Anything to add there, Commissioner?
I think you articulated it well, Christina. We're all individuals. We all have our own take as far as how to handle these things. We're exercising what I consider inherent authority. And so we've got a really broad swath of discretion by which to make this decision. And certainly for certain situations, if it's like litigation oriented, I'm not going to appoint someone who's an estate planner, you know, or but if it's reviewed in a special needs trust, then I might review an estate planner, not a litigator. So I do consider what I understand to be the skill set of the individual in my appointments, but I also try to keep things as broadly spread out and neutral as possible. So I'm kind of dancing in line between one school and the other.
And I think that unless local rules change or there's some specific practice or procedure or process, that's generally how things are done. It's courtroom by courtroom at this point. Okay, I think we're on to the next slide, and this is for you, Commissioner Sundeen.
Oh, great. So this is what we talked about before. Basically, a general duty to investigate, know the individual circumstances of the ward. What I look for is tell me about this person. And one thing I find helpful is tell me about their family. Where did they grow up? What's their education level? You know, that helps me understand who this person is and to what extent they can process things. You know, the family history of relationships, those are all helpful bits of information. I think it's twofold. One is, yeah, you're looking at it like a lawyer trying to figure out what are the legal rights and claims here, but tell me about this person. I am trying to manage to the best that I can the life of someone, and I'm sensitive to that. And so telling me who this person is really is helpful. I think it would be helpful to you as a guardian ad litem. And as an advocate, you want to tell the story. You know, use your guardian ad litem as another storyteller to tell your client's role in this. But again, a good guardian ad litem should investigate not just their principal, but the people around it, the support network, find out who those people are, what their relationship history is. I mentioned before, potential claims and property rights, bring it all. You know, tell me what you see as a guardian ad litem. And changes, differences, you know, certain changes, that's normal. You know, at one point in my life, I didn't like broccoli. Later I did, you know, that's okay. It doesn't mean you have to jam, you know, broccoli down my throat because I don't like it anymore, or I used to like it, you know, but if just tell me about this person. I think that's the main thing. And Christina demanded that we include the box of chocolate things because apparently she's a big
There should always be a Forrest Gump. Always. It's true though, because you honestly don't know with any appointment, you know, what, you know, you have no idea walking in what, you know, what you're going to end up reporting. And that's, I think, part of what makes this role, this quasi-judicial role so interesting is some of the freedoms one is allowed and what one can discover as well.
Yeah, and let me say this, I enjoyed it when I was a guardian ad litem because I didn't have a client telling me what to do. I could just dig in that and go wherever I thought things needed to go. And so I think it's a decent role to be in, and just the more you can find out about these people and their relationships, the more you realize what's going on, frankly. And I think the legal rights naturally develop from that, or your understanding, I should say, of the legal rights naturally develop from that. As far as document review, if one is a guardian ad litem and drafting a report, I think it is helpful to provide a list or outline those documents that you have reviewed or had reviewed. And this is part of creating a record. This is part of showing the other parties that you've done your due diligence, that you've looked at all the junk. I shouldn't call it junk. All the documents and
materials.
Yes, like a list of who you interviewed, what those interviews, what you learned from those interviews, stuff like that. That's all helpful. And that's going to add credibility to you and also help the court make better decisions. Anything you want to add to that, Christina?
Well, I also like to be careful about in my report how I'm not a capacity expert, right? I'll leave that to the neuropsychologists on some level. But what I like to provide to the court is in a report, when I do an investigation and speak with someone who's alleged to lack capacity, some quotes or some description of what the discussion was like to give the court some perspective. Instead of having this person on the stand, I'm the quasi-judicial officer kind of headed over to someone's home or care facility in order to interview and speak with them. And so I want to make sure and provide a good picture to the bench officer of what went on during that discussion.
Yeah, and let me follow up on that. So you don't need to necessarily make the call as far as whether they lack capacity or not, but sometimes anecdotes and little bits of information can frankly answer it for you without having to say they lack capacity, because you don't want to necessarily say that to someone who's looking to you for help. Like I had one case where the woman's daughter stole over $100,000, like going gambling and stuff like that. And when I asked her, she wanted her money back, but she couldn't quantify what that is. And so just the fact that she couldn't quantify it told you that she wasn't able to settle. She wasn't able to know where that endpoint is. She just wanted the right answer. And so she needed help in that. So I didn't need to say she lacked capacity. I could just say she couldn't articulate, what that proper amount was. And there's ways to do it. I do want to point out there's one last bullet point, the interview with third parties. I think that's incredibly helpful. The individual participants, they've got an axe to grind, and finding someone who doesn't have an axe to grind and figuring out what they understand the situation to be, what their understanding of history can be really helpful. And finally, formal discovery subpoenas. I don't think I ever engaged in any formal discovery when I was a guardian ad litem. Again, that's just setting up front that, hey, you want me to know your side of the story. Talk to me. Give me all your stuff. Show me, prove your case to me. Don't tell me, show me. That was my take. And subpoena records, I don't think I subpoenaed records either, but I like subpoenas.
Yeah, I will say I have responded to discovery. And again, echoing something we both mentioned earlier, an effort to keep costs down. Sometimes if a case is like a trust litigation matter, if it's a litigation matter, you'll automatically be on the discovery list. And in an effort to keep costs down, sometimes I've been able to more informally email the counsel and say, hey, I've got an email relevant to this. Can I just forward it to you? Or, as opposed to racking up costs with some formal response. And often that has been sufficient. So when one does receive discovery, there are different ways one can deal with it, as long as that's acceptable to the to the party, to the counsel. So that's an option to check into as well. I'll pop on to the next slide.
Yeah, and I'll finally say, I think you're crazy if you're serving discovery on a GAL. Once when I was a GAL, someone served over 100 requests for production of documents and requests for special interrogatories. And I just answered them all. And then I charged it. If you want to play that game, that's stupid. Again, anything that I learned as a guardian ad litem, I have disclosed to everybody in the court. So just ask me, I'll give it to you. Anyway, so the Probate Code 810, we brought in this assessment of capacity is for twofold. One is for understanding when a guardian ad litem may be appropriate, and two, for one's work as a guardian ad litem is understanding that, one, there's a presumption that everyone's got capacity, whether that's true or not. Obviously it's not. Two is that under current law, it tries to do a kind of a skills based upon a lack of mental functioning. I will just let you know that on the horizon, there's currently talk about more of a life skills based assessment of capacity rather than a mental functioning based assessment of capacity. Since ultimately that's what it's all about, is can you function in this world? But currently we're on a mental functioning based understanding of capacity. So tying a deficit with a specific act or decision, and that's technically how you find capacity. And 810C basically says that even if you're, for example, in the case of Sarah D, even if you're bipolar, that doesn't mean that you don't have capacity. You've got to tie the mental deficit to the specific act or decision to have capacity. And again, as guardian ad litem, you're not there to make that assessment per se, but I think an assessment of the capacity is appropriate. And if there are any concerns one way or the other, then articulate that. I remember one time I was a guardian ad litem for this guy who was, I think he had MS or something like that. He was in a SNF, but he was 100% capacity, like 100%. His body was failing. And also finally, one point out, as we all know, with certain people, myself included, we have good days and bad days. So I think having an in-person meeting is critical to establish a rapport. I know it's harder because of the pandemic, but a follow-up phone call or two is helpful. You got them on a on a good day or bad day, or to make sure that things haven't changed, stuff like that, and also to establish that rapport. We cited Lintz v. Lintz. Actually, there's a typo in there. It's at page 1352, not 1342. And the Lintz case basically followed another case that, and I think you're all aware of the Lintz case of Andrews versus Hunt, which basically found that a trust amendment was closer in its complexity to a will, and so used the testamentary capacity standard of 6100.5. And again, this just reinforces the probate code 810 capacity issues is capacity based upon how difficult or easy the decision or task is. The easier the decision, the lower capacity need. The more complex the decision, the higher capacity one needs. And then finally, there's a definition of probate code section 4609. I think it's a great one. I think it's good enough. I don't know why they have all these different ones, but just a simple one like that. And I shouldn't say, I understand why they have all these different definitions. They're trying to fine tune a 4609 articulation into more specific things to give people guidance. But I think 4609 just says sufficiently enough for anything, as anything I've seen out there. I'll just say that. And then next page, there's some other, again, that capacity isn't anything new, nor is it specific to probate. There's other presumptions out there in the civil code. So anyway, don't be afraid to look beyond the probate code. I found some good authority outside the probate code, even in the corporations code, in cases involving that for like fiduciary duties. There's some great cases out there. Yeah, and this is what I pointed out before about you should report conversations, confusion, lack thereof. You know, again, the deeper you can tell me about this person, the better. I want to know who this person is. A lot of times people kind of forget that, or they say it in a very verbose way that is hard to stomach. But just, you know, a few anecdotes can really be informative about who this person is and what their values are and how well or not well their brain functions. And just think about that. And finally, the 730 evaluation. I think those probably will come up more and more as we have an aging population. Again, all of these things like the guardian ad litem, it's resource driven. There's lots of people who don't have the resources to pay for these kinds of services. And I would consider a guardian ad litem a service, or evidence code 730 evaluation a service, to hopefully help understand this person, get to the right answer, get to a good answer too. It's just another tool. A 730 expert is basically where the court can appoint an expert to opine or find a certain fact about someone or about the situation. It could be an auto accident, could be capacity. It could be, for example, if it's a care manager, about their best interest. Those probably less because there's so much subjectivity involved in that. But anyway, I think
the last couple of slides, we've in a way touched on them already in our discussion. A guardian ad litem's role is to investigate and report, to indicate concerns the guardian ad litem might have as in going through that investigation and providing that information to the court. One example is, you know, for instance, a guardian ad litem may be appointed in a trust litigation matter and think that in the guardian ad litem's opinion, maybe a conservatorship is in order here in light of the facts and circumstances as the guardian ad litem sees them. A GAL does not just go out and file a conservatorship. A GAL indicates concerns in a report to the court and sort of, I think of it as sort of laying that, not making a recommendation, but sort of laying those concerns out at the feet of the bench officer and then seeing where that goes. If the guardian ad litem receives instructions to file a conservatorship, then off you go. I also wanted to talk about, you know, best practices different people have different opinions about this. When I'm appointed as a guardian ad litem and the person alleged to lack capacity is represented by legal counsel, or any party for that matter who has counsel, I always contact counsel. I just don't show up. I have at this point never been refused access to anyone alleged to lack capacity. And all parties at this point have been willing to speak with me. It certainly is possible that a party would refuse. I would simply report that to the court if that's what happened. And then, there's the issue of discovery then as well, and how that could fit into that situation. So again, revealing the concerns and sort of laying that out specifically to the court as far as any next steps if another proceeding might need to be initiated in the bench officer's opinion. Anything there, Commissioner?
No.
Okay.
You did a great job, Christina. How about that?
Okay. Ooh, wow. Ooh, can't believe it. Affirmative filings and objections. Again, be circumspect, sort of lay that at the feet of the bench officer. I think a guardian ad litem's role is to point things out and to move forward on that basis after making that report to the court. And I think I'm just going to pop on to the next slide because I know time is.
Let me address that one thing. So
go ahead.
I did a fair amount of guardian ad litem work before my current position, and I think only once did I file an objection, and it was because someone was trying to jam a petition down my ward's throat without me having a chance to investigate it. And that's the one that resulted in like 100 plus, requests for discovery. I do know a case, I was not involved in it, I saw it as a bystander, where the guardian ad litem filed objections and went to an evidentiary hearing. The guardian ad litem lost on the trial of those objections and then sought fees. And so that's, I think, a good horror story of why you need to be circumspect. Just laying out the concerns that you have and then asking the court for instruction is easily the best way to go, because then it also gives you like a little prejudgment. You've got now credibility as to the viability of these claims. It gives you leverage in the future, as opposed to just whittling off and filing objections. Again, I think I mentioned before, show me, don't tell me. You can show the court your concerns and they'll pick up on it. They'll see, oh yeah, I have some concerns too. And I can think of a couple times where I asked for authority to file an affirmative action on behalf of a ward, and the court said, yeah, go ahead, file your affirmative action. And then I've got the protection of the court that I'm filing this because the court thought so. If things go sideways, well, I've checked in at each stage to make sure I'm doing the best I can. I'm not acting as some renegade person who knows better.
I think another thing to pop in here and say is that, clearly there are guardians ad litem who are not attorneys and who do not respond to discovery on their own or file actions on their own with court approval. So a guardian ad litem can consider hiring counsel to be involved with discovery, litigation, etc. But that is something that one would run by the court prior to doing so, in my opinion, always, because then costs and fees tick up. That's something I would want the court to be apprised of before I did that. Personally, as an attorney, I have not done that. But if it's a fiduciary or someone else in that role, that could be quite a possibility. All right. No authority to settle. We've touched on this earlier. You'll see petitions for approval of a settlement agreement where a guardian ad litem has agreed as to form, and then the court reviews and decides whether the court is the ultimate arbiter of what is in the best interest of that ward. And I am, but a messenger and provide an opinion. I personally have never used Judicial Council Form MC 350 in a probate court. It's minors, generally personal injury cases. There may be some counties or courts that require it. Never done it myself in a probate 1003 GAL appointment. I've never used that form. It's always been a pros petition. Anything there, Commissioner Sundeen?
No, I mean, technically it's a mandatory judicial form, but it's not designed for probate context.
It's very unwieldy.
It's for kids who got in a car accident.
Yeah, exactly. It doesn't make sense. And maybe we will see a form in the future that does make sense, or maybe there'll be a particular probate form. I don't know.
Yeah, they could have an optional one. That'd be good.
That would be lovely. And I'll leave 23 to you, slide 23.
So I'm going to work from the bottom up.
Okay.
If you're a guardian ad litem, negotiation is litigation. Don't just compromise for no reason. Position your ward, because like, again, you're not an advocate, but you kind of are. You're protecting their interest, and trust the adversarial system. I will tell you, the view from the bench is that there aren't enough, quote, aggressive guardian ad litems out there. Trust that, you present what your concerns are as guardian ad litem, they say what their concerns are, and let us find that middle ground. We all like to be friendly and cordial, but your job is not to be friends and make friends. Your job is to, work for this person who can't speak for themselves. And again, without filing affirmative claims or whatever, I think you can position your ward to get the best possible result for them. Bring a critical eye, verify, just let me see what you got. Don't tell me, show me. And understand that your position means that, frankly, your voice is a neutral one, something the court will look toward. That's something that you can use when you're asking for information or when you're stating your position in negotiation. Listen, I think X, and the court could disagree with me and believe your client, but there's a good chance the court's going to view me as a neutral and follow what I want. And again, just be aggressive. Or I'm totally fine with that. The beauty of litigation in our adversarial system is it really highlights things. When you pull things apart with litigation and competing interests, you see all the details and the nuance of the issue that's presented. And it does actually make for better decision making. It's a little uncomfortable. No one likes to fight. I appreciate that. I don't like to fight either. But that's the business we got into. And so don't be afraid of that. That's my biggest takeaway is that being aggressive, fair, guardian ad litem, and the court will love you, frankly.
I also going to say, just to essentially agree with Commissioner Sundeen, when appointed, you're not a rubber stamp. You are there to pick things apart, to suss things out, to form your own, neutral opinion. Even if that opinion is not what the ward or the person alleged to lack capacity may profess to want, and that can be difficult sometimes. But you have to go in with sort of a willingness to sort of push back on what seems to be expected, and also a willingness to not to appear one-sided in your investigation as well. It may turn out that one does agree strongly with one position or another, but you develop a position only after a good investigation, etc. Anything else? I think we may be ready for some questions. Our contact information's on the back.
We're like 5-6 minutes to the end, so it's perfect, I think.
Yes, I am back. Thank you, Christina and Ruben, for that amazing presentation. I learned so much about the guardian ad litem role from you today. Our audience has a lot of questions, which we're going to try to get answered. We have about 5 minutes set aside. So if there's anything we don't get answered today, we will follow up after the presentation. As a reminder, if you have any questions, please submit them into the Q&A icon at the bottom of your screen. And in order to see all of us, you can click on speaker view in the top right corner of your screen. So hello, Christina and Ruben. We can get started with the first question, which is, what is a private professional fiduciary defined as?
I'll just say simply, it's a licensed professional, just like a medical doctor. But they're a fiduciary is representing the interests of someone else, acting selflessly, which is frankly probably impossible. But they're individuals who have shown qualification to be licensed as a professional to handle the roles of a disinterested neutral.
And I'm actually going to ask a question on that question, which is, that is in California, right? Fiduciaries aren't necessarily licensed in every state.
Yeah,
Just in
we
case
are
your
one of
audience
the
member is
first-
not in California.
one of the first, if not the first state to have that as a licensed professional, I don't know, status, position. I don't know what the term is. Professional. It's just a profession, just like a doctor.
Thank
Or
you.
a lawyer.
Yeah, it has strict licensing requirements and annual reviews and fees, and it's monitored, by the state of California.
Yep.
Great. Can any party make a request for the court to appoint a guardian ad litem?
Within limits, there's probably go section 48. It's got to be an interested party, but yeah, anybody can make the request. It's 100% the judge's call or the commissioner's call, the judicial officer call. Generic term.
Or bench officer.
Bench officer, yeah. But yeah, anybody can say that this is an appropriate situation for a guardian ad litem.
Thank you. Can a guardian ad litem represent on civil, probate, elder, or dependent adult restraining orders?
Good question. Yeah, any legal proceeding involving the interest of a compromised individual, a guardian ad litem could be appointed. And in fact, actually, I'm not aware of situations, I don't do restraining orders cases, but I think it's a good place for them.
And I think that some of the cases we've even cited in the talk involve like a 300 case or involve a lot of proceedings that are non-probate proceedings. So if you even just pull up some of the citations, except for the one that was listed incorrectly, the 1352 instead of 42, Lintz v. Lintz, you'll see a number of cases involving situations that are not, most of the cases cited are not probate cases.
Can an individual who you feel needs a guardian ad litem object to the guardian ad litem?
100%. That's the In re Sarah D case. The mother who was bipolar in a dependency context, she didn't want the guardian ad litem because the guardian ad litem disagreed with what she wanted. And so, yeah, and the only thing is you have to have the right to an informal hearing, i.e. the court can hear you in whatever form they deem that appropriate, but it's the court's call. But yeah, you have the right to object. Everybody does.
Great. This questioner says, my understanding is that it's difficult to conserve seniors who have assets and family, that to protect individual rights, a durable power of attorney would be the preferred option. It says, I think the Sonoma County Conservator website states this. Is the law different from county to county?
The law is not different from county to county. This is governed by state law. In theory, what is it? 1818, something like that, 1810, I think, of the probate code. Conservatorships are considered a last resort. They don't articulate it that way, but it's supposed to be the last resort. It is not the preferred outcome or resolution of management of a compromised individual's affairs, but it is also the only tool that we have if, for example, there's undue influence where and I've seen this, where one kid gets power of attorney signed, then a month later, another kid gets a different power of attorney signed, then the other kid gets power of attorney back. The only way to stop that kind of tug of war is to conserve it and say no one gets to have mom sign informal documents. It's all done through the court. Or if you don't have planning and haven't taken care of affairs, or if our agent under, for example, a power of attorney for financial management absconds with funds, then obviously that was a bad choice. And then our remedy is not to have them sign a new one, but to conserve them and then seek recovery. But no, it's a last resort across the state of California. There's every human, every judicial officer is different. So there's going to be obviously some differences in where that line is drawn, but it's supposed to be a last resort without a doubt.
I'm also going to jump in and say, in a more general sense, the laws are the laws. I mean, the probate code is the probate code throughout California. What an individual bench officer or what a county's general pattern and practices can vary greatly, particularly in this area involving court-appointed attorneys and guardians ad litem. And there's legislation in the works to try and clean that up a little bit. You know, there's been some confusion about which role is which. You know, a court-appointed attorney should zealously represent the wishes of their client. A bench officer arguably should not be asking a court-appointed attorney, well, what do you think, attorney? Because that's not your role. And apparently in some counties, though, that is done or has been done, and hands have been slapped at the appellate level. So I think there's an effort to sort of clean up this whole area. And as more people lose capacity, we're going to hear more and more about it.
Yeah, so if I can piggyback on one thing is that, of course, everyone's aware of the Britney Spears case. Even bench officers are aware of the Britney Spears case. And I wasn't there. I don't know the details, but there was some weird stuff going on. Like I read, and this is just me reading like the gossip columns or whatever, that her court-appointed lawyer said that she had like a meltdown in the hallway. What are you disclosing that for? That's not your job. That's maybe a guardian ad litem who's got a duty to just provide information to the judge. But I know that there's some legislation to really carve out
right.
that, no, a court-appointed lawyer is an advocate 100%. And if Britney Spears says, I want to put all my, I want to do X and X irrational, he argues for X. Let the court determine what's the rational outcome. And the guardian ad litem is supposed to be that tempering, you know, influence, force, player in that dance.
Right.
But yeah, I know that some counties have different ideas of what the court-appointed lawyer is supposed to do and have a kind of quasi guardian ad litem role. I think that's inappropriate.
Yeah, agreed. Strongly. I do not like that practice.
Yeah, I don't either.
And it puts an attorney in a it puts one in a very awkward position.
Yeah, or is that your lawyer or not? Who are you? You know. Anyway, and that's the whole. The law operates on a one lawyer, one paradigm that this person's got your back 100%. And to have anything less than that is problematic.
Thank you. Commissioner Sundeen, I know you needed to leave.
There
are 3 more questions. We can send you them and follow up with the questioners after the webinar, because I want to be respectful of the time you have for us. I am going to be, you can both turn our cameras off. I'm going to stay on and say a couple things, but thank you so much for being with us.
Great.
Thank
And
you for listening.
Yeah, and thank you. And anyone with the questions, welcome to shoot me an email. Our contact information is on the back of the PowerPoint.
Yeah, and let me say this. I always appreciated LAS's conferences. So thank you for putting them on.
Thank you. So with that, we are going to wrap up. Again, thank you to Christina and Ruben for the insightful presentation. We'd also like to thank our top sponsors. At the diamond level, Michael Stevens, Probate and Trust Realtor, and at the platinum level, Campbell Green LLP, Trust and Estates Attorneys. Special thanks to our gold level sponsors, Acuna Regley LLP and the Tile Shop. Special thanks also to our silver level sponsors, Anderson, Yazdi, Huang, Minton and Horn LLP, Fiduciary Accounting Services LLC, Holland and Knight LLP, and Professional Fiduciary Association of California. At the bronze level, we have 21st Century Care Solutions, ARM Homes, Evans Law Firm, Golden Gate Fiduciary Services, the Office of Sonoy Rousseau, Law Office of Phillips and Phillips, Lifelong Medical Care, and Meredith Taylor of IMT Associates. We also have our special benefactors, Dan Thomas of Office Information Systems and the Office of Supervisor Wilma Chan. Today's presentation and recording will be available on the LAS website following the conclusion of this series. If you need CEU credits, please look for the post-event email in your inbox in the next 48 hours with further instructions. We welcome your feedback about the webinar so that we can continue improving on the content we provide and on your experience. A link will be included in the post-event email. We invite you to sign up for our last presentation in the webinar series by visiting the LAS website at lashicap.org and going to events. Our next program is Victims' Rights in the Criminal Justice System, Marcy's Law, on October 5th at 12 p.m. For any questions or comments about today's webinar or the program as a whole, you can email us at conference@lashicap.org. Thank you again for joining us today, and we wish you a great rest of your week.